Hello and welcome. This is Legal Focus. Today we continue our focus on alternative dispute resolution here in Nigeria, and one of the ADR mechanisms that have shown great results and greater potential is arbitration. Now the Young Arbitrators Network is expanding the penetration of arbitration with this year's international commercial moot competition. Later on the show, an exclusive interview with Senior Advocate of Nigeria, Chief Robert Clark. And then we'll tell you all you need to know about dissolution of marriage within the Nigerian legal system. Welcome.
We are beginning to evolve a society and a world where most cases cannot be treated in the courtroom.
Babajide Olusegun and his fellow law undergraduates make up one group of participants at the 2019 International Commercial Arbitration Moot Competition. It's the third edition of the Lagos Court of Arbitration Young Arbitrators Network initiative. The other category of contestants is for young lawyers. The aim is to expose young professionals to best international arbitration practices and provide them with a platform to exchange views.
Let them get an idea of what an arbitration hearing looks like and how it is different from a litigation. There are very few instances where people can see arbitration proceedings because arbitration is a very private proceedings. So this is an opportunity for them to see how a live arbitration would actually be.
The participants are from Ghana, South Africa, Kenya, Egypt and Nigeria. Out of the entries of 20 universities and 26 law firms, the finalists are narrowed down to 2 contestants for each of the 2 sets. The program is intensive, despite the short period to prepare, and the cases at hand are real-life situations. On D-Day, the contestants marshal their points before seasoned arbitrators who head the tribunal. The event is also a fertile avenue to make observations on the system of arbitration in alternative dispute resolution in Nigeria.
I liked the fact that it was a way to settle disputes out of court. It wasn't really tiring like the old normal my lord, your lordship kind of way. And as such, it made conversations and dispute resolutions easier than the normal way, and it was more civil to me.
Arbitration allows parties to come resolve their disputes amicably based on voluntary participation. So unlike litigation where the court can compel your appearance and all of that, all of those technicalities and rigidities not applicable in arbitration.
When costs are awarded in arbitration, they are heavy. So parties are mindful of the arbitral process and of the costs involved in being the cause of any delay. So everybody works hard to make sure that it is done. So it is exceptionally faster and quicker and more effective.
Though arbitration serves as a complement to justice delivery in other climes, it offers a welcome relief to the challenges pervading the court system in Nigeria. But practitioners also highlight clogs in the operations.
Arbitration is probably less popular in Germany than it is, for example, in France or the UK. But it is increasingly used for domestic disputes in Germany relating to, for example, corporate matters, where parties are interested in confidentiality primarily. As it concerns speed, our national courts are acceptably fast in resolving disputes.
The Arbitration and Conciliation Act states specific and limited instances in which an arbitral award can be set aside. But lawyers, particularly the lawyers for the side that is not successful on the arbitration, now decides to go on appeal, and it just serves to frustrate the arbitral process.
The Lagos University and Strachan partners emerged top winners this year. This platform also sparks calls that more opportunities should abound to pass on knowledge and gain experience relevant for modern-day legal practice.
And our big story from Abuja this week is Department of State Services secures court order to detain the convener of Revolution Now protest, Omoyole Sowore, for 45 days, pending the conclusion of its investigation into the charges of terrorism brought against him. The Federal High Court in Abuja granted the Department of State Services permission to detain the publisher of Sahara Reporters and convener of the revolutionary protest, Omoyele Sowore, for 45 days. Operatives of the DSS had on August 3rd arrested Mr. Sowore over his call for revolution ahead of the revolutionary protest, which held in some parts of the country on the 5th of August.
The unjust detention of Omoyele Sowore.
Ruling on an ex parte application by the security agency to detain Mr. Sowore for 90 days to investigate him for treasonable related allegations, Justice Taiwo granted the DSS permission to hold him for only 45 days.
I am carrying out a historical duty. Only history can judge me, not a prosecutor or a federal judge. I'm not worried about that. I'm not worried about that. You can't kill somebody who's not afraid of death.
According to the judge, the 45-day period started from August 8th to September 21st, the date he also fixed for hearing in the case. He, however, said the order of detention for 45 days was subject to renewal for further days upon an application by the security agency in the event that its investigation could not be concluded within the first 45 days. Justice Taiwo held that although the hearing of the application was one-sided as legally allowed under the provisions of Section 27, subsection 1 of the Terrorism Prevention Amendment Act, he said he had to act on the facts alluded by the applicants in the application until the contrary was proven. He noted that he had watched the video clips attached to the applications as exhibit, one of which was said to have shown a conference held by Mr. Sowore and the leader of the proscribed indigenous people of Biafra, Nnamdi Kanu. The other, also a video clip, was said to have shown Mr. Sowore saying that members of the Islamic movement in Nigeria, the body of the Shiites movement recently proscribed by the government, would join forces with him to bring down Nigerian government. The judge also said that the word "may" in Section 27, subsection 1 of the Terrorism Prevention Act is directory, robbing him of the discretion to decline to grant the application. He said the word "may" is not always "may," sometimes it is equivalent to "shall." See PDP versus Senator Aliu Madu Sheriff. I have looked at the facts presented by the applicant. I will fail in my duties if I do not act on those facts, at least until the contrary is proved. I shall therefore grant the application only to the extent that the applicant shall detain the respondent for a period of 45 days in the first instance, which may be renewed upon application by the applicant for further number of days if investigation is not concluded by the applicant within the first 45 days granted by the court. However, Mr. Sowore has challenged the court order which allowed the Nigerian government to detain him for 45 days. In a motion filed by Mr. Showore's lawyer, Femi Falana, the activist is asking the court to vacate the remand order and discharge him of all allegations. According to Mr. Showore's motion, which was based on 19 points, the motion ex parte which resulted to his recent remand order neglects his fundamental human rights as well as the rules of the court. Lawyers and concerned citizens had reacted to Mr. Showore's detention.
The era of revolution or coup d'etat is gone. You cannot change government by unconstitutional means. And I think as it stands today, we are quite pleased that Nigerians themselves have largely ignored the phantom revolution and went about their daily affairs in their usual way of doing their things.
So in my opinion, I don't think Sowore is organizing any forcible change of government. He is not calling for a regime change, neither are other Nigerians who are also protesting.
It is argued that Mr. Sowore merely issued empty threats, but until investigations are conducted, and this is shown to be the case, one cannot say so.
You're watching Legal Focus on TVC News. Our advocate for this week is renowned senior advocate of Nigeria, Chief Robert Isaac Clark. Good day, sir. And thank you very much for granting us this interview in your law firm.
Always my pleasure.
Let's go to the beginning, if you will. How you became a lawyer and what growing up was like for you.
I've always had the intention of becoming a lawyer, right from my school days. However, during our time, there were no scholarships to read law in the universities in Nigeria, and one has to rely on either going to England and do what you call fagburu, and then read through that period, or you study privately at home, do your rapid results college, as we call it then, and from there maybe get into the university. So I was handicapped financially because my dad died when I was only 4 months old, and he left behind for us, 4 of us, only a life insurance policy of £150 then, which was good money. So that saw us through our school life, but could not sustain us through the university period. So my elder brother, who was in a technical college and was to study engineering, I gave him the advantage that, well, he has to do a full-time course. I can still do on my part-time and look forward to the favor of any person.
Right. Okay, and then you became a lawyer. I noticed, or I gather, that you had a checkered education before you finally got your degree in law. Tell us about that period. It appears you were determined to be a lawyer by all costs.
By 1962, I had passed, as a private student, I had passed the intermediate examination of the London University in law. However, due to financial restraints, I couldn't carry on with that active private way of reading. I had an uncle then, Dissolution, who was the High Commissioner in England, and also it came in through the time the Civil War was to come in. So he was able to get me a scholarship to study industrial relations. It's a 9-month course in Ruskin College in Oxford, and I was able to do a 9-month course. I came back to Nigeria in 1967, hoping to return to my trade union work and still read privately to become a lawyer. So I came back in 67, but by 1968, 69, I discovered that most of my colleagues in London were already lawyers and were coming back home. And I knew that I was better than them in class. I was doing, well. So I decided I had to go back and read law. And by the grace of God, because it was His grace, I was able to get a scholarship from the Nigerian Ports Authority.
And then let's have, what about your friends? What about your peers then, that were more or less significant in that period of your life?
Most of my classmates were already back in Nigeria.
Right.
Virtually all of them at that time. Most of them had qualified 4, 3, 5 years before that date. So I was in the midst of my classmates who were already lawyers, and I was being taunted by them, let's be honest about it. I had 2 rascal, friends. They're called Ransom Kuti and Fela Anikulapo Kuti, who were all my schoolmates and classmates, and Obateju Osho and others. And I also had the lawyers amongst them, late Shidi Shweton, Justice Ogun Odunawo, Shidi Shweton, and Odusi. They were already lawyers practicing. And when I talk, and Ben was on,
you're not yet a lawyer.
So
tell us about practice, the journey of you becoming a senior advocate of Nigeria, or let's even look at your breakthrough moments by the time you now entered active practice.
Well, let me be honest. When I was going to the university, I was bonded by the Nigerian Ports Authority to at least serve them for 5 years. But there was a significant case. I was on leave in the Nigerian Ports Authority, and I decided, because we were not practicing in the courts then, 4 of us, just late Justice Kasina Alu, myself, and 2 others, and we were being taunted that, look, we are lawyers who can't go to court. So I decided on one of my vacation periods to attach myself to the prestigious chambers of Fani Kayode and Shwenumo on a vacation job. And I was privileged then to be counsel, to Chief Shobo Shwenumo in a very celebrated land case in the Supreme Court. Unfortunately, the family we won the case for advertised it in the Daily Times, and my chief legal officer, saw that I was practicing private practice. That was what he called it then. And I was so annoyed that you people say we don't go to court. I'm using my own time to go and gain experience, and you are still saying I was doing private practice. So that was the what made me to leave the Ports Authority into private practice, to join Fani Kayode and Shwenumo's chambers. Actually, I met late Chief Fani Kayode in a court representing Ports Authority, and I believe he was so impressed. And he called me, "Young man, come here, come here. Which chambers are you?" I said, "No, I'm in the Ports Authority." "What are you doing there?" "Come to my chambers." And that was how I was plunged into prestigious chambers that were handling prestigious and high-flying cases.
And gained the needed experience.
And that is how, with my background as a trade unionist, because you can't compare me to a fresher from the law school, because I had attained, a stage in my life that I negotiate on behalf of my trade union before top management. So practicing law was not, like a new thing to me. And that's how I just plunged myself into it.
Wow. And rising through or learning all the things you had learned as a unionist, in private practice as well, under the chambers of Mr. Fani Kayode then. Tell us about, other key cases you had now, where you had good moments or where you had bad moments.
When I was with Fani Kayode and Shwenumo, I had the opportunity to handle election petitions in 1978, 79. I knew I did what they called the Damaturu local government elections then, and the late executive president of Nigeria, Shehu Shagari, I was his lawyer then. And it was a case which, if I had not won then, would not have propelled some of the people there to want to contest election, like late Kam Salem, whom also I represented during the gubernatorial elections in 1979. So I had been pushed into a high-flying practice right in my younger days. So I saw that if I go out, I must maintain that standard. And by the grace of God, I've been able to maintain that standard.
But did you have any worst days? Are there days that you would tag as this has to be the worst days in my career?
I wouldn't tag any day as the worst day. The worst thing that can happen to a lawyer is when you lose a case which you thought you were going to win. Then we had no problems about courts. And one is sure if you do well, you will win your case. So I really cannot pinpoint a particular day where I was not happy. But let me say of this. I defended the late Ejibadero along with my senior partner, both from the Court of Appeal then in 1978, I think, or 77, 78, and the Supreme Court. So I was able, the day judgment was being delivered, I wept in court that day. That was the first sentimental case, I would have said, because I believed, and I still believe till today, that the man was not guilty.
This was a celebrated murder trial.
Murder. Right. I was his lawyer. I was being led by late Chief Shobo Shwenumo. And when the pronouncement was being made by the Supreme Court, I really wept. Because the man asked me, what are they saying? Because, and I said, I couldn't tell him. And I started crying. It was then he knew that something was wrong.
Your kind of practice and advocacy has, I know I'm not speaking alone, I know this is not just one opinion, has enriched, legal jurisprudence and of course, the nation, Nigeria. But for you, what would you like to be remembered for as we end this interview?
You see, that instinct of a trading honest still reflects in my practice. I like to help those who have been oppressed. I like to fight for the rights of people. And the greatest case, I've done cases where the principles of law have been restated through my cases, either in the realm of receiver managership, either in the realm of government acquisitions. I have been able to make a mark in those areas. But one of the greatest cases that I still cherish today, which is now at the Supreme Court level, was the case of one of these judges. I am not saying people are corrupt or are not corrupt, but if there's a principle of law, because I didn't like the way judges were being handled. How can you go, a judge, and carry a judge from the chambers straight to the court to stand before another judge? I am not guilty, I'm guilty. And I felt it was wrong. That procedure was wrong. Because if you are going to be judged by your peers, which is what the Judicial Service Commission is for, if the doctors can be judged by their own peers, if the Bar Association can be, the judge in the rights of practicing lawyers, why should a judge not be cried first by his peers before you carry him, So I decided, and I think I represented about 4 or 5 judges. I've been able to, get them off except the present one I'm handling.
You're referring to the Justice Nganjua trial?
Nganjua's trial.
Right.
And I was able to establish through that case that you just can't carry a judge straight from the chambers as a judge and straight to the dock on a criminal charge. And I'm so happy. And I know that case will stand the test of time for many years to come.
Chief Robert Clark, Senior Advocate of Nigeria, thank you so much for this interview.
It's always my pleasure.
And that's The Advocate. Legal Focus continues in a moment. Stay with us.
Welcome to today's edition of You and the Law. Today, we'll be looking at matrimonial proceedings, specifically dissolution of marriage, otherwise known as divorce. What is dissolution of marriage? It's a matrimonial proceedings initiated at the High Court to dissolve statutory marriage, which is marriage under the Act, as we had explained at the previous edition. What are the grounds for divorce under the law? Under Section 15 of the Matrimonial Causes Act, there is only one ground under which marriage can be dissolved. What is this ground? That section says that marriage may be dissolved if the marriage has broken down irretrievably. Note, if the marriage has broken down irretrievably, it means that that marriage is liable to dissolution. Under this ground, there are several factors that can give rise to a matrimonial proceeding for the purpose of dissolving a marriage. What are these factors? What are these grounds that are subsumed under this generic and omnibus ground of irretrievable breakdown of marriage? We have, number one, that since the marriage, either of the parties, the respondent, which is the person against whom matrimonial proceedings is initiated, has refused to consummate the marriage with the petitioner. The petitioner is the party that goes to court, the party that initiates the proceedings for the purpose of dissolving the marriage. Now, when a person alleges that the other party, that the respondent has not consummated the marriage, what that means is that since the marriage was celebrated, since the marriage was entered into, the respondent has refused the petitioner, which can be either husband or wife, depending on who the respondent or the petitioner is, to have intercourse, sexual intercourse. Where either party refuses to consummate the marriage, that is an absolute ground to dissolve the marriage. Another ground for dissolving marriage is adultery. That since the marriage, the respondent has committed adultery and the petitioner finds it intolerable to live with the respondent. This means that One, the petitioner who is going to court to have the marriage dissolved is alleging that the respondent has committed adultery. But in addition to that, the petitioner must also state that he or she finds it intolerable to live with the respondent, meaning that where a party to the marriage has committed adultery and the other party indulges, excuses, or tolerates that act of adultery, that will not justify a petition for dissolution under Section 15 of the Matrimonial Causes Act. That party must also find that adulterous conduct intolerable. 3 is that the respondent has behaved in a manner that the petitioner cannot reasonably be expected to live with the respondent. The petitioner cannot reasonably be expected to live with the respondent because of the manner that the respondent has behaved. The fourth ground under which marriage can be dissolved, under the generic ground that I had earlier explained, immediately after the presentation of the petition, the respondent has deserted the petitioner for a continuous period of 1 year. This means where a party to a marriage has deserted the other party within 1 year, immediately preceding the presentation of the petition, that is a ground for dissolution. The fifth ground is where both parties have lived apart, or you can say where both parties have deserted themselves. The husband decides to live apart, the wife decides to live apart for a continuous period of 2 years, immediately preceding the presentation of the petition. That is also a ground for either the respondent or either the husband or the wife to proceed to court and file a petition for dissolution of marriage.
And that's Legal Focus. Thank you so much for watching. See you again next time. Bye-bye.